Get started. My name is Mark Hazelbaker. I'm the attorney for the Wisconsin Association of Campground Owners. So I'm sure I've met almost all of you before. If I haven't, well, we'll meet again. And I see we have Oakwood Wild Rose. I have to say Wild Rose is one of the most interestingly named places because it's not a terribly wild place, but it is a very nice place. I remember going there a lot when I was a kid to Whispering Pines County Park. We used to think that was a really nice place. It was. So there's a lot of beautiful places in Wisconsin. We are really lucky. And the thing about Wisconsin that's so astonishing is if you go about 100 miles in any direction, you really change the kind of place that you're at, you know? You come from Madison north, and then you go past Portage, and you go over through the Wisconsin River Valley, which has a little bit of a contour to it, get into these central sands, and you think, wow, this might be Illinois. And then you go a little bit further north, but it's not. And you go further north, and then you come into the highlands of Wisconsin, where the glacier didn't have as much mud left, and some of the original Canadian shield rock is still pretty much exposed. And it just keeps changing. It's really, really quite wonderful. So we have a lot of wonderful places to share with our guests and to provide really interesting experiences. But in order to do that, we need to have people helping us. We need to have employees. Unless you're a very, very small campground, and you'd have to be very small to not have employees, you're going to have some people working for you, okay? What I'm going to talk to you about today is a very brief overview of the entire range of employment laws that apply to workplaces. Now, it's not meant to make you an expert. I've been doing employment law for more than 30 years. I'm not even close to being an expert. When I first started doing it, my first exposure was I was hired as the personnel director for Manitowoc County, and I was also the county attorney. So I got to learn a lot about employment on the fly. I knew a lot before that from having been a lobbyist and a general counsel. But the fact is, nothing prepares you for being the actual person who is the interface with the employees on a day-to-day basis. A couple things that I immediately learned in that job I'd like to share with you. It was April 14th, 1986. That was my first day on the job. I parked my car in the courthouse parking lot, and I walked in the entrance to the courthouse through the basement entrance. I'm walking down just wanting to see the courthouse a little bit, walking down the hallway down in the courthouse basement, making my way toward the elevator to go up to the third floor where my office was. I got about halfway, and all of a sudden, a guy coming the other way sees me, and he says, "Hey, you're the new personnel director." And I said, "Yeah, I'm Mark Hazelbaker." Offered my hand, he shook it. He goes, "Yeah, I'm Richie. I hope you'll give me my reclass." And I said, "Well, I don't know anything about it, but I'll consider it." Very interesting. I mean, first things out of his mouth weren't, "How do you like Manitowoc? What do you think about raw malting down the street? How do you like those 150-foot high Budweiser bottles painted on the side of the mill holders? I hope you'll give me my reclass." Okay. Well, that taught me something right away, which is that everybody has an agenda when they're dealing with employment issues. Okay, everybody does, and understandably it's self-interested. That's not necessarily bad. Rabbi Hillel said almost 2,000 years ago, "If I am not for myself, then who will be for me?" And he was right. Who will be for you? But he also followed that up immediately with, "If I am for myself alone, then what am I?" And that's the role of the personnel director, to make sure that we think about the broader picture. Within a very few weeks, I had a lot of adventures as I got to handle the job and do things. And I realized very quickly, probably the most important lesson that you need to keep in mind with regard to employee relations, okay? And I'm absolutely serious. It's sort of humorous, but it's not humorous, it's true. And that is, no good deed goes unpunished, okay? You want to be nice to you want to be good to your employees, you want to be fair to them, you want to be supportive of them, you want to be positive with them. But invariably, when you try to be quote unquote good to them, do them a favor, it will backfire. Treat them fairly, treat them professionally. But if you try to be their friend, if you try to be nice to them, if you try to be good to them, and I don't mean to say that you studiously neutral back. Have a positive, friendly, and supportive attitude toward them, and have policies that are supportive and good and even as generous as you can be. But, you know, the other thing I'll tell you about having been a personnel director and having done all this stuff and practice employment law, let me ask you a question. Do you think when I have my own employees that I actually do this? Do you think I'm any better than anybody else? Guess again. Because I had an employee, when I had my own law firm, I had an employee who came to work one morning and she just looked so distressed. And I said, "What's the matter?" She said, "My furnace went out. I don't know what I'm going to do. I can't afford to fix it." And I said, "How much is it going to cost?" She said, $2,000. And I said, "I'll give you a bonus." Okay? And I think I convinced her by doing that she was the best legal assistant ever in the history of the world, because she started acting like I am important. You know, it didn't work, in other words, you know. So there's a role there. If I had said, "Look, if you need a loan and you can't get one, I'll find a way to help you." But fundamentally, you got to be careful how you're generous. So how are we going to cover this topic of the broad spectrum of employment? Take a look at the outline if you could. If you don't have one, we'll get you one. Hey. Hi there. How you doing? Oh, we got our youngest future employee there. That's great. Welcome. So I want to start out by saying something that is fundamental to the law and the reality of employment. Wisconsin, like 48 of the 50 other states, Wisconsin is an at-will employment state, okay? Wisconsin, if you remember anything out of today's seminar, remember at-will employment, okay? What does that mean? Well, it means that employment is a completely unregulated, it starts out anyway, being an unregulated, chaotic relationship between you and an employee. You're free to hire somebody for any reason. You're free to fire them for any reason. You can set their compensation or their terms and conditions of employment at any set of terms and conditions you want. You can change it without notice. You just can't do it retroactively. And it's totally a matter of the market, okay? So, oops, sorry about that. That's interesting. Kingston, Surrey County, Jamaica. That's obviously a serious call. I have $5 million I need to get to US because of coronavirus. Now that I think about that, we're all going to be getting those emails in a few days. Okay. So anyway, at will means, let's say that, let's say my car out in the parking lot needs to be cleaned. So I say, I want to hire you. Go clean my car. I'll pay you $20 an hour to clean my car. Good deal. You go out there, you start doing it. I don't like the way you're doing it. You're fired. That's it. I owe you for the time you spent. On the other hand, you're doing it. I thought, wow, this is so great. I'm going to pay you $22.50 an hour. And you say, now that you make me think about it, I'm not going to finish unless you raise my pay to $25. And I say, all right, done. Those are all totally legal, okay? You can fire people at will. You can terminate people at will. Why is that important? Because it still is a huge portion of our employment law, that it is employment at will. And I will also say that it is something, the right to fire people for no cause, is very fundamental. If there's one thing that ruined Wisconsin, in my opinion, it is when the local governments and the state government created the idea that employees should only be fired if you could prove to the satisfaction of a court that they didn't deserve to be working. But that's another story. All right, so employment at will is the basic rule, okay? Now, of course, what the right hand giveth, the left hand can take away. That's the basic rule, and your rights as an employer have been curtailed by legislation. But, and this is a really important but, all of the rules that apply to employment, that layer on top of the at-will authority you have as an employer, really only take away a very small portion of your ability to manage, okay? They really do. You still have an enormous amount of ability to be creative, to be directing, and to be managing your employees. It may not seem like that, and after I'm done, you're gonna say, wait a minute, you just spent 50 minutes just listing the employment laws. Are you telling me that it's really that general? And it still is, because the one thing the government doesn't tell you is that you have to hire somebody, or that you don't need somebody. The government doesn't tell you what kind of jobs you do, what you have, that whether you can consolidate jobs, et cetera, et cetera. You still have an enormous amount of discretion to manage people. So keep that in mind. You're still the boss. That said, let's start talking about some of the ways in which your authority as an employer is curtailed. If you turn to the first page here, talk about employee rights under the Fair Labor Standards Act. Okay, now this is the brochure for state and local government employees, but it's the same for private sector employees in most parts. And you also have on the following pages the Wisconsin minimum wage law and the Wisconsin maximum allowances for board and lodging, which I'll talk about real quickly. In 1938, Congress adopted this law called the Fair Labor Standards Act, and that was the first federal law to regulate employment practices ever. The Fair Labor Standards Act made two big changes. One is it created three big changes, pardon me. Created a minimum wage, okay, which today is almost moot because nobody pays anybody $7.25 an hour, or very few people get paid $7.25 an hour. The law also requires that, with certain exceptions, one of which applies to seasonal businesses, so you don't do this often, you have to pay employees at the rate of time and a half if you work them more than 40 hours in a week. And the third, which has been by far the most lasting and consequential provision of this law, was it banned child labor. Child labor used to be an enormous problem in this country before 1938. Kids would be taken out of school when they were literally 9 or 10 years old or younger and sent to work in factories. They would be used to replace adults who were getting paid twice as much. They would get injured in factories. They never got an education. They never had a childhood. It was considered, and it was, a travesty. We do not have child labor in the United States today, thanks to this law. So it really did make a difference. There were reasons why it was important to do it. For your purposes, you need to be aware that we have to pay people wage rates. They have to be rates that are understandable, and they have to meet the minimum wage laws. If you're not a seasonal employer, and some of you might not be because you might be open too much of the year, but I doubt it in Wisconsin because we're a highly seasonal state, you might have to pay time and a half. If any of you are open more than 6 months a year, you can ask me about it, and I'll tell you, we can talk about whether you're a seasonal, but I doubt that you are. On the other hand, I've given this presentation in the Carolinas last year, and when I talked to them about seasonal, I tried to talk to them about seasonal camping, and campgrounds. They looked at me like, "What? What's a season?" Because they have people there. They have people living there year round, so they have to pay overtime. Okay, so Fair Labor Standards Act. You'll note that Wisconsin, helpfully, has its own Fair Labor Standards Act, and it's on page P5 and P6. The minimum wage law is right now the same as the federal law, although there have been many proposals to increase it. But there is a provision which is shown on the page that has P6 on the bottom, which talks about a couple of provisions that are maybe material to camping, and that is that there is a, yeah, I agree. There are maximum allowances for board and lodging. These are the maximum that you're allowed to deem that people have to pay out of their pay.
You mean deduct?
Yes.
Okay.
Yes. For employees, for meals and for lodging. There's a camp counselor employment for board and lodging rate, which is combined. These are minimum weekly salaries for all employees, okay? You'll look and you'll see that they're basically the same as the minimum wage. P7, if you turn, there is a special provision for workers who are disabled. This is something that's been increasingly controversial in recent years, and it may be getting repealed. And then going on, page P8, minor employment, non-school days, it looks pretty much the same, 8 hours, June 1st through Labor Day, except that if you have adult, over 18 employees that you work 10 hours, and some people do to cover sunset, you can't work children more than 8 hours. It's even in the summer.
Is this continuous
No,
hours or?
no, it's not. It's you can stagger the shift if you need to.
Well, right. Can you have them work 5
Yeah.
hours in the morning? And
Yeah, that's what a staggered
4
shift
at
is.
night?
That's what a staggered shift is.
Not more than 8 hours.
No, you can't. No, not more than 8 hours.
You can't go more than 8
No,
period in it.
no.
Okay.
8 hours in your 24-hour base period.
Okay.
I have a question too.
Go ahead.
Back on so I just hired this kid and he really wants to work and he wants 40 hours and I said, I can give you 40 hours. He goes, well, can I work overtime? And I'm like, no, because I don't want to pay overtime. But if he wants to work 41 and 42, is the law I have to pay him?
It depends on whether you're a seasonal employer. I did look at this, and my recollection was that few employers. Okay, my recollection is that almost all of the campgrounds qualify for the seasonal exception for overtime, but almost none qualify for the seasonal exception for unemployment comp. But I want to check that again. Okay, so don't quote me on that. Go ahead.
While we're talking about minors, you said something recently about breaks
Yes.
for minors.
Yes.
And I didn't fully understand that. I was wondering, that break, does it need to be paid? Can they clock out? Because I assume that they're not allowed to be asked to do any tasks at all during that 30-minute time period?
Correct. They are off the clock. If you call them back in, you have to give them the break back. You have to give them the remainder of the break back.
Okay.
Okay. So if you put a kid out on break and then you have an accident or something, you need all hands on deck. You can call them off a break, but you're going to have to send them back off and let them finish the break.
But so does minors mean literally anybody
Under 18.
Okay,
Yep.
I didn't know if we were still at the 14, 15-year-old, or.
No, it's
And just to clarify, so then if you scheduled them for 8 hours, but you give them a half an hour break, that they're off the clock, you really schedule them for 8.5 hours with
Right.
that half an hour break in there.
correct.
Okay.
That's a big one.
So one thing I noticed here that I didn't realize before is that permitted time of day is 9 p.m.
Yep,
And that's an off, that's when school is out.
correct.
I didn't realize that.
Yes,
Yeah.
they're not supposed to be working third shift. Yes, go ahead. Good question. Who enforces this? The answer is the Department of Workforce Development enforces it. And if you violate it, they can fine you. Most often, the first time it happens, if it's if it's like a one-time violation, they'll send you a letter and demand that you pay people what you owe them. But if repeat violators, they can come down on you like a ton of bricks. If they saw somebody, for example, working minors in prohibited jobs where if you had 14-year-olds working with lathes and other dangerous machinery, believe me, they'd come and see you real quickly.
Are they auditing, actively auditing things, or were they?
Very rarely, but don't try to get away with it. But no, DWD has not been terribly aggressive about auditing. Go ahead.
So like this chart here, we have some kids that are like in a private school, and so they may start school or end school not in these dates.
Mhm.
Are these dates solid dates?
They're solid dates.
Okay.
They're solid dates. Okay, we got to move on. Or we'll take some questions later.
All right. Opportunity, non-opportunity.
That
Employers.
opportunity, it means people that are economically disadvantaged and certified as qualified for a sub-minimum wage. Probably you're not going to get anybody like that. Okay, I'm going to move on to mention that Fair Labor Standards Act also, and keep moving ahead to the section of the outline that says wage and hour laws. If you go to the second page of that, you'll see that it contains an element called record keeping requirements, okay? This is the laws, this is I would call the foundational requirement for having some kind of personnel file, all right? I hope you all have some kind of personnel file. I hope that you take care that it is kept in a secure place, that it's kept in good order. Frankly, you don't have to get to be a very big employer at all to discover that having an electronic personnel system of some kind, QuickBooks has one, for example, and scanning all your documents and keeping them electronically may be a better solution for you because you'll be able to find things when you need them. But if you do whatever format you use, the information you have to have is contained in that laundry list here of the 14 items. This is the minimum. You can have more. You need to keep track of when your employees start work, when they are on break, and when they go off work. Whether it's a time card or a time clock, and time clocks are much simpler today because you can use a personal computer to do it, and then they automatically journalize the time and log it into your payroll system, so they're worth thinking about. But whatever, you need to have a record of when people work. Why do you need that? Well, if only because if somebody hasn't punched in or is not recorded as working on Thursday and they claim a worker compensation injury on Thursday, you've got some proof that they weren't really injured, okay? I would take this requirement as an opportunity to say, you know, I really want to know what's going on with my employees. I'm going to keep track of everything, okay? I want to keep track of when I change their pay rates. I'm going to have a piece of paper that says, given a 25-cent raise for this reason, okay? I'm going to move on quickly because time flies. Equal employment opportunity. This is the non-discrimination law, employment discrimination, Title VII of the federal law. It's called Title VII. It's also the Wisconsin Fair Employment Act. It says that you cannot discriminate between one employee and another on the basis of a number of protected classes, okay? And those on the federal law include race, color, religion, sex, including pregnancy, or national origin. Wisconsin adds disability, handicap status, and sexual orientation and marital status to those list of classifications. Okay, what does that mean? Well, it means, and in fact, there's also other, in the Wisconsin, by the way, these documents that are in here are documents that you may recognize as the posters you put up or you're supposed to put up in your break room. And I developed this program because I was pretty surprised to see that when I talked to employers or asked them, when they asked me questions, they would ask me really basic things, and I'd say, well, but don't you know that you're covered by the Wisconsin Fair Employment Act? No. Well, don't you have this poster in your break room? Yeah, but I never read it. Well, guys, think about something. Yeah, some of you have teenagers or had teenagers, and for that you have my condolences. But would you give your teenage child a document that tells them what they're entitled to, but not read it yourself? Think about it. Think about it. And the only difference between teenagers and employees is that teenagers actually have a little bit of sympathy for their parents because they know if they're too cruel, their parents will run out of the ability to help them down the road. Employees, on the other hand, often don't care. You need to know what's in these sheets. Okay, so Wisconsin protects sex, color, ancestry, disability, marital status, race, creed, age, and also use of lawful products, which means you cannot discipline somebody if you find out that they're vaping, which is a legal product. You can't, if somebody, believe it or not, somebody comes to work and they're not a CDL driver, and they brag to you, yeah, I went down to Rockford last weekend and I bought some dope and I smoked all weekend. That's legal in Illinois now, as questionable as that is. You can't discipline them for that, okay? Well, you can drug test if you want, but if your requirement has to be legal, okay? If you have a job, if you have an, I'll talk about that real quickly because it illustrates a point. If you have a position for which being clear of THC is a bona fide occupational qualification, you can not only drug test randomly or whatever, and you can fire people for having a dirty urine screen. But what we're going to be coming up with fairly soon, and actually in Colorado they're already there because they've had legal marijuana for a long time now, is that there are plenty of jobs where, you know, if you're not running a meat slicer, if you're not, you know, if you're pushing a broom, it's hard to tell somebody, well, you were smoking dope last night, you're not qualified to push that broom, you know. And unfortunately, the other reality is that if you, in Colorado, if you tried to prevent people who have THC in their blood from working in many jobs, you wouldn't have anybody to work because the pool of applicants has become a bunch of stoners, okay? So, or not everybody, of course, but a lot. It's serious. You know, Colorado, you ask an ER nurse in Colorado what they've seen and they'll tell you. So, what is the significance of these anti-discrimination laws? What they tell you is that you have to deal with people on the basis of you hire on the basis of knowledge, skill, ability, and experience, you know, basically their ability to perform the job. You discipline and pay and terminate people on the basis of performance, on the basis of how well they do the job for you. So, you know, you can't say, for example, I'm sorry, I don't hire young women because, well, you'll just get pregnant and have a baby and then you won't be available to work for me anymore. That's a stereotype. It's not right either. Bottom line is, you have to manage to the position, and you have to evaluate and manage to the performance, not to the characteristics of the employee. Okay, you see my point? So, I don't know about some of you are like me, over 40, over 60. And even though we do have this prohibition against age discrimination, let me tell you that it's very clear that the stereotyping of older people in this country is huge. Nobody wants to hire me. Sorry, that's why I'm self-employed. If I applied for lots of law firm jobs for which I am very qualified, nobody's going to hire me because they all have stereotypes about, you know, if you're over 60, you're slowing down. You don't really want to work hard. You just want to coast. Well, that's not fair. It's not, and all of these stereotypes are wrong. You know, imagine if this gentleman here, if you went to Illinois and somebody said, I'm not going to hire you, you're a Packer fan, which, by the way, actually would be legal. It's not illegal to discriminate against Cubs fans or Bears fans. In fact, some might argue it's meritorious, but you know, whether it's good or not is another question. But it's, you know, it is arbitrary, and the thing is, you're depriving yourself of somebody who might be a good employee. The significance of this in the day-to-day world is when you're interviewing people to hire them, the interview questions and the selection decision needs to be confined to the qualifications of the job, okay? So you certainly can't ask somebody, how old are you? You know, do you have any physical disabilities? You know, you can't ask about whether someone can physically perform the job until you've become convinced that they're qualified, and you make them what's called a conditional offer of employment, which is, I'm going to offer you the job provided that you can pass a pre-employment screening physical. Now, if you were, for example, if you're hiring somebody for an Amazon warehouse, I don't know if Amazon does this, but I'm just hypothetically, an Amazon type warehouse, where people are going to have to do a lot of rapid movement and a lot of physical lifting and a lot of up and down, you could say, your credentials look good. In your last jobs, you have showed up reliably. You did pretty good on the dexterity tests that we gave you and the like. So we're going to make you a conditional offer of employment. It's conditioned upon you having a pre-employment physical and screening, and you can go put people through a process to see from a doctor or a functional capacity evaluation if they can do everything you require them to do. You're still not going to catch a lot of things. You're not going to, for example, catch stamina and stick-to-itiveness and other characteristics like that. But if you really wanted to do it, you could do that. It's expensive. So odds are you're probably not going to do that. You're probably going to simply look for experience, and if people don't work out because they are not motivated, well, you fire them because they're not motivated. If they prove unable to perform the job, though, physically, or they come to you and they say, geez, I thought I could, lift this bale, and I can't. That's where you're going to get into difficulties, because then they're saying to you essentially, I'm disabled and I need an accommodation. And I don't have time to talk about reasonable accommodations, but basically, let me just say you have to give them, you have to attempt to work with them to find a way for them to do the job, okay? I'm going to move on and talk about our next topic, which goes way into these materials, and that is OSHA, Occupational Safety and Health. OSHA has been around now for, this will be 50 years this year. In the early years, OSHA was ridiculed because people thought that they were doing too much. The fact of the matter is that occupational safety has changed a lot in this country. When OSHA was adopted, work was very dangerous. Employers did not often, and it wasn't that they were cruel, it was that they just were often using old equipment. There weren't proper shields on things. Work was very dangerous. People lost, you used to see people with lost fingers and the like. That's changed a lot. Work is much safer. Smart employers are very aware of the need to make sure that their employees are properly protected. Campgrounds are, you could say, well, we're safe, but then you might say, well, if it's so darn safe, why did you guys get that liability law passed in 2016 that we did? There are dangers, of course, natural environment things. We want to make sure that we follow all the restrictions and the rules that apply to various things. You'll probably, if you have a pool, obviously you'll take that CPO. Somebody will have that CPO class, and there's coverages to talk about the handling of the chemicals involved. That pool chemicals are probably the harshest things that campgrounds come across. If you use pesticides and herbicides, that might be an issue too. You have to make some decisions as an employer about how you want to have pesticides, herbicides, and other chemicals applied. The kinds of chemicals that are used for cleaning, so if you have people cleaning cabins or cleaning your bathrooms and the like, usually those are pretty good, but the basic thing there is tell your employees to follow the labels. And if they seem a little resistant to that, go over the labels with them, because then you can say, well, covered it, okay? What about OSHA? Are they really the evil ogres that people have made them out to be? Well, they can be. People got roofers for a while were a little in a tizzy because OSHA was going around and actually enforcing the rules that apply to roofing. Roofing's very dangerous, okay? OSHA has a rule that if you're working on a roof that is it is not flat, you have to mount, either you have to have safety harnesses and all kinds of woozies, or you have to nail a temporary barrier at the bottom of the slope to catch the employee if they fall. Seems overkill, but believe me, if you've ever seen an employee who fell off a roof, and I have, it doesn't sound like overkill at all. So now you see a lot of workplaces putting harnesses on people with safety lines, and they're not cheap, but they prevent a lot of injuries. So if OSHA shows up, they are required to ask your permission before they come onto your property. I would invariably say, no, I'm not ready for you, and then call me. Okay, if OSHA, seriously, call and find out what's going on. If you have an injury on the job, you're required to report it under certain circumstances, and they may respond to that injury report. You have to cooperate with them. Don't try to hide things, it'll make it worse. The cover-up is always worse than the problem, okay? Next topic, unemployment. Unfortunately, many of us are not excluded from unemployment because we are not seasonal employer, but whatever the rule is, unemployment is basically a no-fault guarantee that you can get money from the employers that you worked for the last 52 weeks. And they start with 52 weeks ago and draw from that person's unemployment account until you've gotten the maximum benefits. The only way to deny someone unemployment compensation if you have terminated them is if they are found guilty of misconduct, which means intentionally undermining the interests of the employer, or they have repeatedly violated a rule that is communicated to them in writing, okay? How do you protect yourself from many of these issues? How do you set yourself up for success? Well, I'm going to put a pitch out there for something that our firm did for Waco starting 2 years ago, which is we wrote a set of sample job descriptions. We wrote a sample handbook, and I'm going to talk about employee handbooks tomorrow in more detail. And we also wrote a sample job employment application for you to start with, just like we have the seasonal agreement. Now, you shouldn't just use those. You should take them and adapt them to your needs. But why do we need to do that? Well, let me give you a hypothetical. Let's say that, and some of these things have actually happened in the time I've been working with you. Let's say that you hire a bunch of people, a bunch of young guys to work for you as your seasonal groundskeepers, okay? No job descriptions, no wage rate schedule, nothing. You hire one guy and you say, hey, I'm gonna have you be the marina groundskeeper. I'm gonna have you be the roads keeper, because you have a big park, a lot of roads. I'm gonna have you be the garbage guy, okay? Jobs are very similar, but you have in your mind how these are different, right? You do your best to try to explain the jobs, but within 2 days, the fact that it's clear in your mind but not theirs means they're overlapping. You know, the guy who is the garbage guy is out there picking up garbage and emptying garbage cans, you know, doing the transition, sees stuff on the road, picks it up and puts it in his garbage can. The guy who is supposed to clean the roads sees that and says, hey, wait a minute, that's my job. Why are you cleaning the roads? Well, I was just there, you know. Or you decide that as you're interviewing people, you think, well, this guy that I hired to do the roads, he looks like he's 19 years old. He doesn't really have any experience. I'll pay him, I'll just give him $7.50 an hour. And the guy that is doing the garbage is a little older, seems like he's got some experience. I'll give him $8.50 an hour, you know. You just pull things out of the air. You can do that. At-will employment allows you to do that, but then comes the problem, how do you explain the differences between these if these jobs are essentially identical? And here's the real kicker. What if the guy that you pay the lower wage rate happens to be a protected class member, whether he's Hispanic or African American or has a disability, or it's a woman versus a man kind of thing? If you can't explain the distinction, it creates a presumption that it was an arbitrary decision, and in fact it is an arbitrary decision. And if you make an arbitrary decision which burdens a protected class for no reason at all, then under our discrimination law, you're going to be presumed to have discriminated, and you're going to have to come up with a reason for it. So how do you deal with that? Well, you use job descriptions to try to define what the job is, okay? And you have a wage schedule to define what you deem to be worth paying for, okay? I have a feeling almost all of you have some kind of a wage schedule where, you know, you pay people a little bit more if they've had some experience. You may have a job progression where if you hire somebody back for a second season and a third season, you give them a little bit more as an incentive for them to do well and come back, on and on and on. Then you have something that's consistent. Can you deviate from that if you need to? Sure. You know, one of the nice things about at-will employment is, let's say that somebody shows up at your campground in an RV and says, you know, I've been thinking about resettling and actually settling down again in Wisconsin. I'm a retired machinist. I've had years of experience as a carpenter. I do a little light electrical, grew up on a farm. I can do anything. I'd really be interested in a job as a all-around maintenance guy. People like that are pretty scarce. And you think, wow, this is great. You can create a job for that person. You can take duties away from other people. You can lay off somebody in order to have the money in your budget to do it. And sometimes, it's like that, like they say in the football draft, you draft for the best available talent. Sometimes that's the way it works in the job market, okay? That said, you know, there's a limit to how far you should go. You know, if the guy says, well, I want to be your all-around maintenance guy, but I don't want to do fences. Well, wait a minute, why wouldn't you want to do fences? I just don't like fences. Well, I'm going to put it in your job description, and if that, you know, that maybe you don't want to let people custom write their own job to too great an extent. So what I'm really saying is set some rules that are going to apply. So if you did create this job description for this person that happens to be in the labor market that showed up, know that you're going to offer that same job if somebody else, if he leaves, that's going to be pretty much the job that you use to try to recruit somebody else. Of course, you can modify it, but my point being that it's meant to be the job descriptions are meant to tell you to tell the world who you would hire. Okay, do you follow me? Now, why is that important? For a number of reasons. First of all, let's say somebody who is a protected class member shows up at your campground and interviews, right? And you just don't think that they've got enough experience. They don't seem to have the right customer service attitude. They don't make a good impression on you, which is a perfectly permissible reason not to hire somebody. Okay? You don't have any job descriptions. You don't have any requirements for experience or anything like that are stated. You don't hire them, you hire somebody else, and it turns out when you actually look at the facts that this person you didn't like actually has just a little bit more experience than two people that you did. Suddenly you could be in a position of having to explain why did you not hire this people? And you say, well, it was about experience. You don't have job descriptions. The response is, well, you don't have a job description. How have you documented what experience you actually require? That's one example. There's another. Somebody comes in and gets hired, something happens to them, and they no longer can do something important that was part of the job in your mind. No job description, it's in your mind. You say, sorry, I can't accommodate that disability because you have to be able to walk out on a pier in order to pull people out of the water or something like that, whatever. No job description, you really can't prove that that's an essential element of the job, okay? And Wisconsin is one of the more difficult places for that issue because Wisconsin actually requires that you rearrange the duties of jobs, take a job from one person and give it to the disabled person so that they don't have to do the pier walk, and you can give that to somebody else. So you really need to define it for that reason. As far as wage rates, you know, employees talk. I know that's going to shock you, but within a matter of days, they will all know how much each of them is being paid. And if one of them is getting paid 7 cents an hour more than the other, and it isn't obvious why, you know, they're going to go, what in the hell is this all about? And they get angry, you know, because everybody thinks that they deserve this, everybody thinks they deserve the same rate of pay, except, well, I should get a little more because I'm more special. You know what I mean? So if you can show people, this is our pay matrix, this is our pay grid, and you could even put in there, employer may give a premium of 25 cents or whatever per hour for people with exceptional experience or qualifications or something like that. And you can do that. And by the way, there is a sample wage grid in our materials on the Waco website just to get you to react to it. It makes you think a little bit. Okay, does that make sense? You know, basically, if you can tell your people going into a season, we have a set of expectations. We have taken the trouble of defining what the jobs are. We've defined what you're expected to do. We're going to manage you by comparing you to what you're expected to do. You know, you tell them what's expected of them. And then, of course, this handbook that we'll talk about at the seminar tomorrow makes the package complete by setting forth the expectations from A to Z so that they have it and you can tell and you can document later if problems arise. I did tell them, okay? By far, though, the most important thing in employment is communication. You know, you need to tell your employees what you expect of them in a positive way, and you need to work with them when they're not meeting your I'll answer your question in a minute. You need to communicate with them when they're not meeting your expectations. And you need to do it in a way that recognizes something very fundamental, which is people basically are looking in life to feel good about themselves. They're looking for self-esteem. All of us are, you know. When somebody makes a mistake, you know, I was a kid 2 weeks ago, it seems. But when I was a kid, I was working at the Audiovisual Center in the high school where I went to high school in the summer. And we had just gotten in this new device called a video cassette recorder, right? These were the first Betamaxes, and those things were big. They were literally this big, and they weighed about 70 pounds. They were huge. So they were brand new. You know, the technology was really new. And the AV director said, "Hey, Mark, would you put the Betamax recorders on separate carts so that we can move them around?" And I was like, okay. Because I wasn't, you know, I was a little bit smaller than I wasn't as strong as I am now. So I'm supposed to move a device that's this big and weighs quite a bit and put it on a cart like that. And I got it about here, and I'm putting it here, and all of a sudden, boom, my arm gave way, and it boom, and I dented the corner of the VCR. And these were like $2,500 in 1974, you know. Fortunately, they were purchased with grant money, but even so, I was like, oh shit. I went to Mr. Allman, the director, and I said, "Mr. Allman, I'm sorry, but I dropped the VCR putting it on the cart, and it's got a dent." He said, "Well, let's go take a look at it." I said, "Well, I'm sure it's going to still function. Mark, you're a good employee. I know you, and I should have asked you if you were strong enough to handle that. Let's move these. Let's have 2 people move these from now on." And I said, "Thank you." He said, "But in the future, if you feel you can't lift something, just feel free to tell me, okay?" That's management, okay? I felt terrible. The fact that I remember it 46 years later tells you I felt terrible, right? People make mistakes, you know. People make big mistakes. I've had secretaries over the years put the exact worst possible letter in the exact wrong envelope and send it to the wrong people. It makes, you know, human mistakes happen. You just have to roll with the punches because we're here for the long haul with our employees. Okay? Now, you had a question.
I
Yeah, you talked about job descriptions and unemployment. So if you put in a job description that you're hiring someone as a seasonal employee and they're gonna work from June 1st to August 31st, and that was part of the job description, and then you no longer employ them after September 1st, can they file unemployment?
Whether or not they qualify for unemployment is not controlled by the job description, it's controlled by state law. And the answer is I'm pretty sure we are, in most cases, covered by, and let me verify that before I say the wrong thing, because we have an exclusion. There are seasonal exclusions from overtime and from unemployment and a whole bunch of other laws. I need to review them before I sound off. I should have reviewed them before today's. Go ahead.
Unemployment, can they file for unemployment if they quit as opposed to you
No.
letting them go or terminating them?
Quitting is, if you quit, you cannot collect unemployment. But then when people go to the unemployment office and they are told you can't get unemployment because you quit unless, so they may come up with the, they usually don't, but sometimes they'll say, well, there was good cause attributable to the employer, which sometimes there is. You know, for example, if somebody was sexually harassed in the job place, that they're allowed to quit. If you cut their pay by 30% or more, they can quit and you have to pay them unemployment. There's some exceptions, but basically if people quit, you don't have to pay them unemployment. Go ahead.
I have a question about employment law.
Can I finish the one answer? Somebody quits to take a better job and they get laid off within a week, they can't come back after you because they quit. Go
I
ahead.
had them do that.
Yeah.
And I tried to fight it, and the state said, nope, you're paying
Give
it.
it to them.
Well, that's right there because it's base period wages. Yeah.
Yeah.
Give it to them.
I just have a question about the employment law for under arrest and conviction,
Yes.
because we are a family campground
Yes.
and none of us wants a child predator on our payroll. So how does that work if you do a bad...
Good question. It's a very good question. How does arrest or conviction work? Federal law does not explicitly protect arrest or conviction record. Only Wisconsin law does. There have been attempts to either repeal or cut back arrest or conviction discrimination. They have been rebuffed consistently over the past 40 years. Wisconsin says that you can first of all, you can't fire somebody because they're arrested at all. Okay, so you have a family campground, you find out that last night your camper was arrested for selling heroin to children outside a church. You can't fire them for being arrested. However, you are allowed to make your own investigation and to fire them on the basis of facts that you learned through your own investigation. And your own investigation can consist of getting a copy of the police report and reading it and becoming convinced, well, the police report convinces me that you were selling heroin. And I've had people call me where employees have been found passed out from heroin and whatnot, and I assure you, we rapidly do our own investigation and we write up a letter. If you ever have a situation like that, I'll help you with it. But we write a letter and say, let me finish this and I'll get to you. We just tell them you're being terminated because our investigation concluded that you were using heroin or selling heroin. Conviction records, on the other hand, are a legal basis for employment actions, provided that they relate to the elements of the job. In your case, the campground has a bunch of children. Sex abusers definitely are not, there's definitely an argument that they're not qualified to work around kids. So that would be an essential element of the job. Question?
Don't some employment contracts have a morality clause in it? But we will probably want to do that. You see
I hope not.
people get fired because of
Yeah.
morality.
Well, the morality clauses tend to be used in contracts involving lots of money for highly visible people. They are falling out of favor they're falling out of favor because, frankly, morality has fallen out of favor. People's sense of what is unacceptable morality has changed so much. people really don't care anymore. Maybe that's good, I don't know. But campgrounds, if you're hiring a camp counselor, asking them to sign a contract that they will not engage in immoral behavior is probably a bit of a reach, you know, because we're dealing with people that probably have a very different sense of morality from us. And you also cannot get, people cannot waive their rights under the Wisconsin Fair Employment Act or Title VII. So if somebody says, I promise that, or I agree you can fire me if I behave immorally, that doesn't allow you to fire them because they've been arrested. You go ahead.
So the whole campground sex offender, do you need to put in your job descriptions that they will be working with children? Or like they will be around children, or how do you? Or
I would.
Because it's a campground, it'll be fine.
Somewhere in your employment materials, the fact that children, or for that matter, elderly people, or disabled people, you know, if you have a campground that has a significant disability population, those should be mentioned. It could be in your handbook, just so that you can document that before this person was ever hired, we had made a note in our handbook or in our job descriptions that the positions involve working with children. There are very few campgrounds that don't have any children, are there? I mean, I know there are some that target older guests, but most of them have grandkids that show up too. So, but it's worth mentioning. Go ahead.
Now, during the interview process, can you ask them if they can pass a background check?
Sure.
So that would help with that, right? 'Cause
You certainly can. You can ask him, will you, the way to ask that question is, do you have a problem, do you have a problem with the employer conducting a background check to see if you are given an offer of employment? Now, that by the way, if I'm a smart young kid, I would say, well, what kind of background check? Okay, so you better be prepared to answer. And the answer is, well, we're looking for whether you have been convicted of any crimes that are the smart.
We have a bar, so we ask that because we
Yeah.
don't know if they can
You have to
get a
be,
liquor license.
then the answer is, you have to be eligible to be licensed as a server. Other questions?
Yes.
Go ahead.
Do all of the laws apply to your own children? If you own a business and you have your 15-year-old working for you, can you make them work 70 hours?
That would make you a bad parent.
Well, one of my kids wants to work a lot more, and we don't let them.
I honestly don't know about child labor laws. My impression is that they do, but I'll look for you. Okay. Generally speaking, I would assume that your children they're all covered by the laws. Now, some of the laws have family employment exceptions. I will look. Okay. I don't know the answer to that one. I think
from the state coming down and saying, well, you've got records here to show your own kids have worked 100 hours a week in the summer. Yeah, so I had to when I was on the farm.
I did.
But
we all
there's different rules for farms, and I
Right.
know there
Yes.
was a case in Sauk not that long ago, the bakery, and a child of the parents being under the age of 12, I believe was the issue.
Yes.
And working, I think it might be 12 is the cutoff for being on payroll if you're a family member.
Yes.
But some more clarification would probably be a useful thing for the membership.
It'd be a good idea.
Okay.
Yeah, back to the overtime thing. So if you're a seasonal employer, but you have an employee or two that work year-round, do you have to pay, does that exclude them do you have to pay them overtime potentially?
You might. I'm going to check up on that. There are so many laws that it's impossible
Or
to.
would you maybe be better off to put them on salary then?
Well, salary is a loaded term. You can't put some people on salary. You can't put a janitor on salary because it's not a professional managerial or executive position. Okay, it's not eligible to be treated as a salary. Let me see what looking at the federal. I'm going to have to look this up. I don't want to just take a quick off the cuff assessment here. Generally speaking, though, people, you have to assume the laws cover people unless they don't. So let me take a few minutes and I will be in a position to report to you at the next seminar that I'm doing tomorrow on employee handbooks. Okay, I'll update. Now, family exception, seasonal exception, morals clause. I would be afraid of a morals clause. I'm a thoroughly immoral person. No, I know what you mean. Other questions before we break? Go ahead.
So, moving forward, I'm pretty compliant now with my employee files. However, anything past the last 8 years, it wasn't so great. You don't have to recreate all that stuff, do you, if they're long gone?
It's almost impossible to recreate it. That raises a good point, which is there's this wonderful thing called a statute of limitations. For overtime and minimum wage, the statute of limitations is 2 years for negligent violations, 3 years for intentional. Okay, so if the Department of Labor or the Department of Workforce Development found that you intentionally violated the law, they could go back 3 years to 2017. It's just not a good idea. But that brings up your point about personnel files. To circle back to the comment I made about having a wage scale and the like. If you're going to go do that, and I hope you do, please document what you're doing. Okay, so for you, when you decide in July that one of your employees has improved significantly or documented good performance, you want to give them a raise, have a piece of paper, a form, if you want to call it that, in the file, which says John Jones has been given a 25-cent wage adjustment based on above average performance, something like that. So you document what you did and you can explain why. Okay. The nightmare scenario here is one of our campground members had a situation where they had truly some of the most despicable employees I've ever seen. You wouldn't believe how awful this situation was if I told you the facts, and I'm not going to. But they wound up being fired, and they wound up filing a discrimination complaint. And the problem there was that there were slight differences in wage rates, and the employer didn't have a system in place to document what the particular wage rates were, and it wound up costing us several $1,000s in attorney's fees to get that case dismissed. It would have been a relatively easy explanation if we had a wage scale. So you really need to have rules, and this is what you need to do during your off season. So one of the things you need to do. How are we doing on time?
25 minutes.
Okay. We got 25 minutes left? Oh, excellent. That's great. So I've done the overview. Now let's talk about, we'll talk about how this goes from hire to fire, the way that the topic describes, okay? So let's talk about how you first start the whole process. Before the season begins, or when you're starting your campground, we're going to start out by looking at what the functions are in your campground. And we tend to think of employment as being driven by bodies, numbers of people, but really you should look at what the functions are. What do you need to get done? Okay. That in turn says, well, we have to make sure that there are people down at our pier, our swimming area, our marina, to make sure that people aren't picking the park benches up and throwing them in the lagoon, or let the boats out or whatever. We need to have somebody in the store and reception desk registering people, checking people out, making sure they're not stealing, that kind of thing. We need to have people going around picking up garbage, maintaining the trails, scooping gravel into the trails when there's been a washout after rain. You look at where you need people, and of course you know that. All right, so the next step is you think about, okay, well, what am I going to have to do? What kind of people am I going to hire who can perform these various functions? And that is the hardest challenge today because the unemployment rate is very low. It's hard to find good people, and it's getting increasingly expensive to find even unskilled people. So the analysis needs to be, where can we best allocate the various functions that need to get done to, maximize our use of the highly skilled people that we do have. I suspect that it's not unusual for most campgrounds to have one or two people that are very good and they're very skilled. That probably the owner is the ultimate one, but have somebody who's sort of a maintenance person that can handle a lot of the more difficult tasks, and then you have lower skilled people that do the more time-intensive labor. That kind of decision is important in deciding what kinds of functions you're going to allocate to the various jobs, how you're going to set the job descriptions up, okay? So you take those job descriptions that are on the Waco site and you look at them and you say, well, we don't do this, but we do that. We do this, we don't do that. This isn't something we have our office or store clerk do. This is something that we have our yard maintenance person do. It's all fine. Those job descriptions are meant only to provoke your thought process and give you something to react to. But there are consequences, and you need to think about this. The minute that one of your employees steps outside of the campground store, their worker compensation rate changes, okay? And I will use that as a springboard to, the poster isn't in there because usually I don't have enough time to talk about worker compensation, but I will talk about it now, and because it's an important factor in how you set up the various jobs that you do. Essentially, if you're going to have somebody in your campground store, in your campground office, doing the inside jobs, that somebody is pretty much going to have to stay there, because if they walk outside, if they do any work at all, if any part of their duties involves doing outside yard work, then they'll get thrown into that other classification that campgrounds have, which is something like twice as expensive on the worker comp rates, okay? How does worker compensation work? Worker compensation is a no-fault system for providing compensation to employees who are injured on the job. When I say it's a no-fault job, I told you a few minutes ago about my youthful mistake of dropping the Betamax, right? What if I'd been even dumber and I'd been trying to leverage the Betamax this way, and I slipped and dropped the Betamax on myself and broke my arm? Absolutely boneheaded thing to do. How did you manage to break your arm? Doesn't matter. Worker compensation is no fault. I would have, after I stopped screaming, the employer would have taken me to the hospital. They would have set my arm, and the medical treatment for that injury would have been covered because it arose in the course of and out of employment. Yes, it was my fault. Yes, I was negligent. That doesn't matter. Negligence is not a defense to worker compensation. What would have happened would have been that the medical would have been paid for, and I would have presumably been off of work for a day or two while the acute injury faded. And then the employer would have had the question about, well, should we bring him back and give him light duty because with his right hand not in use, what can he do for us? Most of the work I did that summer involved cleaning film strip projectors and tape recorders and checking out equipment and the like. I needed both hands, but I could have worked around. I could have done it left-handed. There were things I could have done, and I would have wanted to keep working. If I couldn't, though, the employer would have had to put me on comp leave, and I would have been. And this, by the way, applies to everybody, whether they're temporary or seasonal or whatever. You pay them. The comp system replaces 2/3 of your income, and it's tax-free. So some employers will even supplement that to give you a little bit more. Go ahead.
stepping out to deliver a bundle of laundry.
I'm not sure about delivery, but I suspect that that might be enough to get you out of the office classification. Go ahead.
That's a good thing to know.
So let's say you go back to you broke your arm.
Yes.
Take you to the emergency room. At that point, can you have them run a drug test?
It doesn't matter.
It doesn't
You-
matter
you-
if they test positive for whatever.
Doesn't matter. Doesn't matter. It's no fault. It's absolutely no fault. You could fire somebody if it turned out that the accident was caused by somebody being under the influence of alcohol.
But you still have to pay them workman's comp. You can't
Absolutely.
argue that if they weren't drunk, they wouldn't have hurt
No.
themselves.
Well, there's one qualification on that, and that is there is a provision in the worker compensation law which says that if an employer fails to make available a safety device that would have avoided the injury, there's a 15% surcharge on the benefits. And if an employee fails to use a safety device, and in some cases, rare cases, to use due care in avoiding the accident, they can be docked 15%. That's your insurance company's decision, though, and they rarely go after those penalties because it isn't worth it. I mentioned insurance. Worker compensation is an insured product. It's an insured program. It's not run by the government. It's not financed by taxes. It's financed by premiums. Everybody has a worker compensation insurance company. You're required to have worker compensation insurance if you pay more than a very trivial amount of wages in any quarter of a year. You all have it, I'm sure. Your insurance company, if they're a good one, will work with you to help you mitigate losses. They will work with you to shape the job descriptions, and if they don't do that, ask your agent. You may find out that you have a great resource. Worker compensation companies are in the business of safety, and I don't mean that cynically. They really are. They have learned, the good ones, and there are some companies out there that are really very good and very aggressive in reducing worker comp claims. They work with employees, they educate them, they make the tools available, and it's all about making sure that people have the knowledge and the ability to stay safe. It's also more than that, because if you have in place the training to give people knowledge of how to avoid accidents and they just don't do it, you can discipline them for doing unsafe things. You can't discipline people for having a worker comp injury, but you can discipline them for negligence. Okay, so you tell somebody, okay, if you're gonna lift that Betamax, we're gonna give you these, you probably have seen them, these shoulder harnesses where you put a thing on and people, I've seen people, have you seen anybody deliver a refrigerator with those shoulder harnesses? Absolutely amazing.
Effortless.
Yeah, it does.
And the guy
Because
said it's a piece of cake with these.
it's leverage. It's all about leverage. And guess what? I'm almost certain that the people that invented that device must have been worker compensation insurance companies, because they generate a lot fewer back injuries, paradoxically, than hand trucks used to, because it's much less effort and you have much more control over where you're going once you're trained in how to use those. And training is a big deal, okay? Worker compensation insurance companies have had a dramatic impact on getting employers to be smart about it and to get employers to stop doing things that are dangerous. A while ago, I was driving in Madison past a construction site. One of the big companies was there, and I saw the employees on the construction site in a circle, right? They all had their hard hats on, they had their lime green vests on. They're standing in a circle doing this.
No stretching.
They had been told, the insurance company had told them, you will have your employees do warm-up and stretching exercises at the beginning of every shift in a circle so that everybody does it, including the supervisors, mind you. And they will go through the following exercises. Why do they do that? And you have to pay them, by the way. That's compensable time because it's part of the day. Why do they do that? Because it reduces repetitive motion, stretching, and muscle tear injuries. It's been well proven. It's also good for you, you know. It does a body good, so to speak. So the worker compensation insurance company should be a resource for you. If they're not offering to help you, contact your agent and say, hey, do they have any kind of safety programming that is available? Will they come out and audit us? Will they come out and help us? That's a lot better, frankly, than learning the hard way. Go ahead.
I got a question.
Sure.
Relating to this, and I probably didn't handle it correctly, but I had an employee's girlfriend come to me. This employee, his knees started bothering him. He's a middle-aged gentleman. And she's like, you know, so-and-so's knee has been bothering him. That should be work comp, shouldn't it? And I'm like, you know, wear and tear on a person's body, did he injure it? He never told me about any injury. But I said, you know, just because he's getting arthritis in his knee or something because he's middle-aged, I said, that doesn't qualify for work comp.
You're right. Degenerative changes to your body are not compensable. So, fact is, I'm 62 years old. I hate to admit it, but I'm not the man I once was physically. Of course, I'm more cunning, but seriously, you do. You know, we wear out. We wear out, and if you do have degenerative changes in your joints, that is not covered by comp. On the other hand, if lifting that Betamax, I can't stop using the same example, I slipped a disc. You know, there have been instances. There's a pretty notorious case of a police officer who was lifting a couple of bulletproof vests into the back of a squad car and reached the wrong way and did something to his back, a disc slipped or whatever. He was retired on full disability from that. So, strange. Where that goes is there is a process in worker compensation called employer's first report of injury or accident, okay? If an employee says, and you need to tell your employees, if you're injured on the job, you must fill out a first report of injury or accident. Even if it's just a cut on the finger, you want a report of injury or accident. Because for two reasons. The first is you want to make sure that the person has dealt with it appropriately. If an employee is out there on the job in the campground and they cut themselves, for God's sake, you want them to wash it properly, disinfect it, and put a bandage on so that they don't wind up with a septic infection that gets really expensive. It's humane to do that, let alone it's practical. And by the way, this takes me to the kind of the important point about worker compensation, which is, what's the big deal about it? Well, why? And I've actually had employers, people say to me, this person is a volunteer, we don't have to provide worker compensation to them. And my response to that is, well, you know, of course you don't, and there may be no liability if they're injured in the course of the volunteer work, but if there is a possibility that somebody is injured in the course of doing something and they might seek damages, you really want them to be covered by worker comp. Why is that? Well, if I'm driving my car and I get into a bad accident, although I've never had a good one now that I think about it, a serious accident. If I get in a serious accident, the damages could be in the hundreds of thousands of dollars, okay? If my employer has me out driving and I get into a serious accident, the injuries, the damages are going to be capped by the worker compensation amount, and they're much less than what a jury can award. I had a client who was in a serious truck accident which retired him as a truck driver forever, and the amount of money he got was a very small fraction. I mean, like literally an eighth of what he would have gotten if that case had been something we could have taken to a jury. The medical benefits, they are covered, but they are also controlled. So the point I'm getting at is that if you're going to have, since employees are going to be injured, it's inevitable, it does happen. Comp is a much cheaper way to compensate them than the tort system, believe me, much cheaper. So The point I'm getting, this ties into this whole thing because when you set up job descriptions, you are thinking about how the jobs are going to be divided among people in the campground, how they're going to be allocated, and what the duties that they're going to have are going to be. Worker compensation becomes material to that because let's say that I did break my arm, and on the Betamax example that I talked about earlier, and the employer, I tell my boss, hey, I want to come back, I want to work, you know, because I want to make 100% of my wages, not the 2/3 that I would get as from comp benefits. The employer can say, well, you're really not qualified to work because your job description says that you must be able to manipulate objects, and you must be able to, you must be able to clean films to projectors, et cetera. Those are jobs that require 2 hands. That's getting a little slippery, and I'll get into disability accommodation in a second, but it may be true, okay? There simply are some jobs that you need 2 hands, a few anyway. The other issue is if let's say that it gets to be I do take the time off and it gets to be 12 or 13 weeks later, and assume I'm not a seasonal, summer employee, but I'm a regular employee, and the Betamax incident is now 15 weeks in the past, and my cast is off, and according to my orthopedist, I've fully recovered, but he says, you're gonna have a permanent, because there was some nerve damage in there, you're gonna have a permanent weight restriction of no more than 20 pounds lifting in your right arm, okay? The job description says that this position requires a high level of physical exertion, and these are the levels of exertion that various positions require have been studied, and they have been documented by the Department of Labor in the Dictionary of Occupational Titles, which is online. So there is an objective body of information out there that tells you that somebody who, for example, who works for FedEx Ground has to be able to lift 150 pounds. Those are very demanding jobs physically. If I had a job which had been defined in advance as having that kind of a lifting requirement, and I no longer can meet it, the employer can refuse to rehire me because I do not meet the job requirements, and they are not liable to me for further wages. The other reason why at this stage, why we're talking about job descriptions and handbooks, although we'll talk more about those tomorrow. The other reason why you absolutely need to protect yourselves by defining what jobs are is to protect yourself from unreasonable demands for disabilities accommodation. I'm entirely in favor of accommodating disabilities, okay? There's no reason why we can't accommodate people with disabilities, but we can't accommodate every person with every disability. There has to be the ability to make business decisions, and we can, okay? But if you don't define what a job's requirements are, when somebody says, I can do that job, it's hard to say, no, you can't, because you don't meet the requirements of the job. Well, what are the requirements of the job? Yeah, I didn't put them down, did I? Okay. Now this becomes especially critical because Wisconsin goes beyond the federal law and requires that, as I said earlier, employers rearrange the duties of jobs. There's a classic case involving a cheese factory where a supervisor had a job where the supervisor was required to go around the floor and up on a mezzanine and all over the place to check various vats of the cheese making process to make sure that they were going properly. The person had an off-duty accident which rendered her paraplegic. She could no longer walk. She was confined to a wheelchair. The employer refused to rehire her because they said, well, she can't get up that mezzanine, she can't get into various places around we can't use her, we're sorry. The Supreme Court said, no, you can take parts of her job and give them to somebody else and give other people's jobs to her, and you can find her 40 hours of work. So it's not as simple as you may think. If you, go ahead, 5 minutes. So you need to define what your essential elements are. with all due respect, and I have nothing but high regard for people who are wheelchair bound, because they're courageous and often very tenacious people. There are a lot of jobs in a campground that somebody in a wheelchair would have a lot of trouble doing. Simple fact, because some of them involve going over natural terrain. But, you know, if you have 16 people working on your, in your grounds, right? And you have paved roads and paved pathways, and the garbage bags that need to be emptied are within the reach of a paved trail, you might have trouble proving that somebody in a wheelchair with a stick and a bag couldn't be involved in picking up litter, and there might be 40 hours of a week of that work. I don't know, but that's why you need to define what your jobs are by job descriptions, okay? So you hire to the job description, you have a set of expectations that are defined in advance with your job descriptions, you have a culture that you define with your handbook, and then you manage people. We talked a little bit about using positive motivation. You want to try to make people feel good about coming to work, and when they make mistakes, help them understand that it's a process of perpetual learning. We're trying to get better, all right? Comes to termination, and I'm going to terminate on termination. Everybody has to fire employees from time to time. It is not pleasant. It is never fun. Sometimes it's satisfying because they really earn it, but it's never fun. A few tips about termination. First of all, use common sense in approaching a termination. If you have somebody who is volatile, then consider where you're going to terminate them and how you're going to do it. Make sure that you feel that the situation is safe. It's a rare issue, but it does happen that people go off. And if there's a possibility that's going to happen, and you'll have a sense of that, I think, because you'll have gotten to know people's temperaments during the employment relationship, do it in a safe manner, okay? When you fire someone, don't beat around the bush. Okay, you call them in, you don't, hey, how you doing? Well, it's pretty amazing. The NBA closed its season down. No. Call somebody in. John, I've called you in today to tell you that we are terminating your employment. We've decided that you no longer will be working for us. Today is your last day. You will be terminated effective immediately. We're going to escort you to your locker so you can get your things, and then you're going to be escorted off of our property, and you will not be returning. I'm firing you because I determined that you were engaging in unacceptable horseplay down at the landing. You were demonstrating how you could jump off the pier backwards and do a flip. It was a bad example to set for the students that you were teaching, and encourage them to, whatever the reason is. Get to the point, okay? Get it over with, get them off the property right away, and don't let them back, all right? They may have friends on the campground that they have acquired during the course of their employment. That's done. If they want to continue that friendship, it's off the campground. They're not welcome as guests, they're not welcome as customers, they're not welcome at all. It's your property, okay? Terminate them and sever the relationship. Don't try to make it anything other than what it is, because, it's nasty. It's not pleasant. Document what you need to document, that is to say, and you should think about what you're going to say in advance, because they'll ask you questions. They'll challenge you. What do you mean I did a backflip? I didn't do a backflip. I did a dive. Well, I'm sorry, but I have to rely on what I was told. Okay? It's not an argument. It's not a discussion. It's an information. Okay? And if you have trouble with, if it's uncomfortable for you to do it, sometimes there are circumstances in which sometimes you have to fire somebody you've had for a long time, and it's very uncomfortable. You just can't quite do it. Have your lawyer do it. I'm not kidding. Just get it done. Absolutely do not ever tell somebody, I'm firing you in 2 weeks. You laugh, but people do it. I'm laying you off in 2 weeks, but, do it in person. I've had employers who send people letters at home. You're fired? Really? You don't even have the guts to tell me in person? Come on. I mean, be real. Be real. Termination is not pleasant, but it is part of the reality. Okay, I guess we're almost out.
Terminated.
Final questions. If you have anything, come up and see me.